call the room to order. Welcome to Eversheds. My name's Matthew Allen and I head up the firm's Financial Services Dispute Resolution team. And it's my honour this evening, together with my partner Neill Blundell, who heads up the fraud group here, to welcome you all to this second event in conjunction with Halsbury's Law Exchange, which follows on from a very successful first event in April, which examined legal reporting in the digital age. Tonight's event will look at the complexities of combating corruption in a global business environment, an issue which is of paramount importance for global companies and their executives. Bribery and corruption has become a hot topic in recent years, and the need for businesses to have appropriate anti-bribery compliance regimes in place is becoming a vital part of the corporate architecture. No doubt we will have a lively debate on this subject, and we have a distinguished panel this evening chaired by Khawar Qureshi QC to lead us through the issues. It's also a great honour to welcome this evening the Solicitor General to Eversheds. Most welcome. He's kindly attended an event here previously when we discussed the consultation in respect of deferred prosecution agreements, and no doubt some interesting remarks will be had from that direction too. I'm now going to hand over to James Wilson, Head of Policy at Halsbury's Law Exchange, who will give a little bit more background to this evening's event. Thank you.
Thank you very much, and good evening, ladies and gentlemen. First, I'd like to say thank you once again to Eversheds for hosting tonight's event and partnering us for the occasion. We have a very distinguished panel, so I won't detain you for long. Just one matter of housekeeping. You should have found on your chairs a small information pack giving some background about HLE and a little bit of background about tonight's event as well. Just a word about Halsbury's Law Exchange. It is an independent think tank. It was set up and is funded by LexisNexis, but it has its own fully independent board composed of very eminent practitioners, several of whom are here tonight. The idea behind HLE is to provide high-quality legal debate and hopefully thereby lead to improvements in the legal system. We at LexisNexis are dedicated to promoting the rule of law. We can support a variety of initiatives such as LawWorks, the Access for Justice Foundation, and of course HLE itself. We take the view that it makes sense that we engage in exercises to improve public understanding of the law, and indeed hopefully to improve the law itself. So far, HLE has operated a blog which has grown steadily. It has produced some high-level policy papers which you can find on the website, and also by events such as tonight, and as you've heard, it's the second one we've had this year, and on both occasions we've been very grateful for the support of Eversheds. I'm sure you'll agree tonight's subject raises some formidable questions, and to introduce the subject further, I'm delighted now to introduce the Solicitor General. So ladies and gentlemen, please, Solicitor General.
James, thank you very much indeed. And can I begin by not only thanking everyone from LexisNexis and Halsbury's Law Exchange, but also the home team from Eversheds for having us here. When John Peck from my office, who's somewhere in here, and I were going around the city to law firms talking about deferred prosecution agreements, we always used to check to see whether the reception area was bigger than our entire office, and usually it was. There was one law firm we went to where the receptionist's cloakroom was actually bigger than our entire office, and one of these days I hope to persuade the government to spend money on my comfort rather than on other things. I'm not going to take too much of your time discussing my favourite subject, which is the introduction of deferred prosecution agreements, not least because if I did so, Felicity Gerry would bite my ankles off. We have come to an agreement. She and I have had a journalistic correspondence over the last month or so in the Criminal Law Review, I think it is, and we've decided that for a very, very large fee, we will write a joint article saying how marvellous DPAs are, and the sooner we get them introduced, the better. You have a stellar cast, and you can see them here, sitting on my right, ahead of you, and so it would be silly of me to take up their time and to delay your enjoyment of what they've got to say. But I did, before they give you the real stuff, just wanted to tell you a little bit about where we are with deferred prosecutions and to persuade you, if you haven't already, to respond to the Ministry of Justice's consultation document, which closes on the 9th of August. It's been open since May now, and whilst I don't wish to be trouble me personally, but I mean, there are people in the Ministry of Justice, Joanne, looking darts at me, who will have to wade through all of the responses to the consultation document. We do need responses because it is essential that if we are to introduce deferred prosecution agreements, that they have consent. I don't care about the villains, but I do care about the legal profession, and I want the legal profession to have a deferred prosecution agreement system in this country which they are content with. So those of you who practice on both sides of the Atlantic, but certainly those of you who practice on this side of the Atlantic, it is important to me that I should have the advantage of your responses by August the 9th. But let me just outline, for those of you who haven't had me walk around about deferred prosecutions before, let me just briefly outline the guts of a deferred prosecution agreement. There are plenty in the room who know all of this rather better than I. But as you'll appreciate, in the United States for the last 30 or so years, deferred prosecution agreements have been used. They developed from the criminal jurisdiction dealing with low-level human offenders, who did not need to be put through the criminal justice system. So the first-time shoplifter, the first-time malcontent, who was much better sorted out outside the formal justice system. So just as we have deferred sentencing, just as we have suspended sentencing, in the United States they developed the system of deferred prosecution. The sword of Damocles was left hanging over the individual for a period, and if they behave themselves during the course of that period, well, then the prosecution was dropped. Well, a woman called Mary Jo White, who was in the US Attorney's Office in the Southern District of New York, said, well, why don't we use this for companies? Why don't we use this for people we can't send to prison? That's to say, corporates and organizations. And she transmogrified the PPA system, which had been used for human beings, over towards companies. And for 25 or 30 years now, companies have been entering into various forms of non- or deferred prosecution agreement with the Department of Justice, and also at state level with the district attorneys from the state of New York, but also in other states, particularly where there are big corporate activity. The guts of a deferred prosecution agreement are this. The defendant corporation reaches an agreement with the prosecutor which sets out the facts of the criminal conduct, often market fixing, corruption, fraud of some sort. The facts are then reduced into the form of what we would call an indictment. And the indictment is posted but not proceeded with. And it is not proceeded with for a deferred period, normally of 2 or 3 years, on condition that the defendant company pays a penalty, and there are quite developed sentencing guidelines published by the Department of Justice. You can look at them on their website. But it's reasonably easy now, after 30 years, as a defense lawyer acting for the company, and it's reasonably easy for the equivalent of the Serious Fraud Office, it's the fraud section of the Department of Justice, to work out what this sort of criminality would attract in terms of a crime. You then agree on compensation if that's appropriate, you agree on whether there should be a monitor, an independent outside body or individual who will monitor the conduct of the company over that 2-year deferred period. And there are levels of monitoring. Clearly, as a defence lawyer, you want to have no monitoring because it's expensive, it's inconvenient, and it has an additional reputational hit. There is sort of light touch monitoring, to use that awful expression, and there is rather more intensive monitoring where the company's behaviour has been bad and it needs to be watched quite carefully. So penalties, compensation, and monitoring for the given period of deferment. And so long as the company behaves, pays the penalty, pays the compensation where that's appropriate, abides by the advice and instructions of the monitor, or then at the end of the deferred period, the prosecution is not proceeded with. There are advantages clearly for the prosecutor. It's quicker and it's cheaper, but equally there are advantages for the defendant company because it is also quicker and cheaper than being prosecuted, and the reputational hit is less prolonged. And strangely enough, there was at least one DPA where the share price of the company went up following the publication of the terms of the deferred prosecution agreement, because it told the world, it told the market that this company had now come to terms with its misconduct, had cleaned up, and was getting on with being a good company. Up went the share price. It has the advantage of certainty. It has the advantage, as I say, of a degree of speed. You don't have the investigation and the prosecution hanging over your company for years and years and years and years. But it also has the advantage of two other things. First of all, there is an absence of collateral damage. Innocent third parties should not be affected by it. I always trot out the case, and I'm sorry to do it again, of Arthur Anderson, which was prosecuted by the Department of Justice in the States in the early part of this century. And as a consequence of the prosecution, brackets, ironically overturned by the Supreme Court some years later, the company effectively stopped trading. And I thought it was thousands, but I was told by the Department of Justice the other day when I was over there, hundreds of thousands of Arthur Anderson employees lost their jobs. Yes, some may have been re-employed, but hundreds of thousands lost their jobs. Pensioners were affected, suppliers were affected, shareholder value was affected. So there are innocent victims to prosecutions, just as there are victims to the criminal activity that is conducted by these nefarious companies. The other advantage, the other collateral damage which is avoided is that if you don't have a conviction, you don't get debarred under US federal or European Union procurement limitations. And I think that can be quite important because some of the companies that we'll be thinking about are the sorts of companies which do multi-million-pound deals with government organisations. Could be in defence, could be in other forms of procurement. And the disadvantage to them of having to go through a long investigation followed by a prosecution leading to conviction, and then, okay, the fine may be bad enough. The debarment is the thing that is most unattractive to the company and its directors and its shareholders. So it seems to me we need to translate that American idea in a form which is acceptable to our jurisdiction. And the big difference which I want to see between the American system and the, I hope, English and Welsh, but British system, is far greater judicial supervision. The one thing that struck me about the American system is that a lot of these deals are done almost too cosily between prosecutors and defendant lawyers. There is a carousel between private practice and government practice in the United States. People know each other far too well in this quite small world of corporate advice work. And I suspect, I can't prove it, but I suspect there are too many sweet deals going on. Equally, it's fair to say the American prosecuting system is quite draconian. They figuratively walk around with a baseball bat and they beat you to a pulp until you agree to plead guilty or do whatever it is that they require you to do. I'm after doing justice, and I'm after doing public justice. Yes, there must be a degree of confidentiality when the corporate lawyers and the prosecutors are discussing the exchange of information and what the implication for that may be. But once the outline of the deal has been struck between the company and the prosecutor in this country, and it will be predominantly the serious fraud office, it seems to me that we need to ensure that there is no oppression and there is no easy way out of this. So the judge must come in, and I would suggest there should be a chambers hearing, confidential hearing, whereby the judge can police the deal. He will need to be satisfied that the arrangements are in the public interest, it's in the interest of justice. He will need to be persuaded that the level of fine, and he will draw down information from sentencing guidelines, are appropriate, that the period of deferred prosecution is appropriate, that the monitor is an appropriate body or person, and that the level of their fees is acceptable. I don't want to build up a cottage industry of article clerks sitting around swimming pools in Bali saying, oh, we're monitoring. That will not do. And I want to make sure that these sweet deals, which allow egregious conduct to go unprosecuted, are policed as well. We will build up a practice and we will get better at this. At the initial stages, I think we're going to need some helpful guidance from the judiciary. But I do want the judiciary to be involved at that early stage. And once the Chamber's hearing has been done and the judge is satisfied that this is okay, well, then you move into open court and the judge will promulgate the agreement. It will be up on the court website, it will be up on the prosecutor's website, the Serious Fraud Office or the Central Fraud Group at the CPS or wherever. People can come into court and listen, and they will know that in this particular matter, in the matter of Edward Garnier PLC, these are the facts which were agreed, which constituted this criminal offence, which has been dealt with by the payment of this amount of money, this amount of compensation, and with this person or body doing the monitoring for this period of time. So it can be followed by the public, and they will know that this is part of an open criminal justice system. It seems to me that that is hugely important, and if we get that right, I think we can do good. We can, yes, make better sense, better use of public money, but we can do justice in public, and that is what I think is important for us to do. Now that's enough waffle from me. Can I end by thanking Matthew and Neill from Eversheds for looking after us this evening and for inviting us to this great building to listen to some top chaps talking about fraud and other and chapesses, talking about combating corruption in a global business environment. Can I thank again LexisNexis, Alltrace for laying on this wonderful event, and may I again urge you, please, if you haven't done so already, to download from the Ministry of Justice website the Deferred Prosecution Agreement consultation document, respond to it, be critical, be supportive, be both, but please do it. And please do it well in advance of August the 9th, because somehow or other Whitehall goes a bit sleepy in August, and I'd quite like to get this onto the statute book by this time next year. Ideally, in October, I want Parliament to be seized of this matter, and ideally by May or June of 2013, I'd like Her Majesty to put La Reine la Vote, and by the end of 2013, the beginning of 2014, I'd like the Serious Fraud Office and you, who act for defendants and corporate defendants in this room, to be sitting around a table and enabling me to show the world what the first British deferred prosecution agreement looks like in Southwark Crown Court or at the Central Crown Criminal Court or wherever it may be in front of the relevant judge. And so that the Financial Times, the Daily Mail, the Daily Telegraph and the Daily Star can say wonderful things and demonstrate that we mean business and that we want to clean up the world of corporate business in this country. Thank you.
Thank you very much. I shall now introduce our chairman, Mr. Khawar Qureshi QC. Mr. Qureshi is a commercial litigation specialist at Seoul Court Chambers. He has vast experience of bribery and fraud, corruption litigation, both civil and criminal, national and international, and so is eminently qualified to chair tonight's panel. He took Silk in 2006, and I'm also proud to say that he was a founding board member for HLE. So ladies and gentlemen, Mr. Khawar Qureshi, QC.
Could I begin by thanking our hosts, Eversheds, Matthew and Neill. Thank you, James, for your introduction, and thank you very much, Solicitor General, for being present here to explain to us the present initiative on the part of the government vis-à-vis deferred prosecution agreements. It's very important that we take up the invitation of the Solicitor General before we all go off on our summer vacations, because one of the criticisms that's levelled at DPAs is the fear that in this particular context the criminality of corporations is glossed over all too easily. The words of Lord Justice Thomas in the Innispec case, where, I think it's fair to say, the Divisional Court was less than enthusiastic about the approach that had been adopted to agree penalties that were to be paid by Innispec in respect of overseas corruption. As has been indicated, we have a very experienced panel. Before I introduce the panel, I ought to point out that in addition to this pack, which includes the biographies of the speakers and various articles, there's an article by David Corker, a partner at Corker Billing, on DPAs, virtually hot off the press, 6th of July 2012. And you've got extracts from the Criminal Law and Justice Weekly, which relate to the impact of the Bribery Act, which came into effect on the 1st of July 2011. I'm told that this document provides you with an overview of an online toolkit, as these documents are described, which assists you, or those who are needing such assistance, to undertake internal compliance. We also have what looks suspiciously like a wad of euros, and maybe that's why it has 0 at the end, but is in fact an overview of the legislative arrangements in various jurisdictions as they relate to bribery. Now for the speakers. We have Peter Binning, partner at Corker Billing, who is extensively involved in defence of matters that relate to bribery and corruption. We have Neill Blundell from Eversheds, who is extensively involved in trying to assist corporations in ensuring that they have what are described as adequate procedures pursuant to the 2010 Act. Susannah Cogman from Panellists, also involved in that area. Felicity Gerry at the bar. Ben Rose from Hickman Rose. Last but by no means least, Satnam Tumani, who is Head of Bribery and Corruption and International Assistance at the SFO. Format for this evening, we have an hour. We will start with a very limited overview on my part, because we assume that all of you have access to the Bribery Act, which is rather slender, but all the better for it. All of you could have access to the joint prosecution guidance of the SFO and the DPP, and you will in due course read what's in this pack. So what we know from the publicly available information is that the first conviction for overseas corruption took place in September 2009. That was in respect of Messrs. Mabey and Johnson, who ended up paying a total of £6.6 million in respect of violation of UN sanctions relating to Iraq, and also alleged allegations that were accepted payments in Ghana and Jamaica. Importantly, that was a case that was generated by self-reporting. Subsequent to that, some of you may be aware of the Innispec case, where there's been recent guilty pleas on the part of certain senior employees of Innispec that related to sale of additives, fuel additives in Indonesia. And there's been an extradition of an individual from Australia earlier on this year who is alleged to have received corrupt payments whilst working for a Bahraini company. That's by way of overview in terms of what we know. We're also told that there are 20 corporations that have self-reported to the SFO in the past 3 years, and there are 50 live investigations. I'd like to turn to Satnam firstly to ask him for an update as to the situation in the SFO. Are those figures correct in terms of 20 corporations having self-reported in the past 3 years, 50 live investigations?
I confess to not having arrived here with a list of all of the self-reporting companies over the last 3 or 4 years have the exact extent of cases under investigation. I would like to add, I think that there are other examples of prosecution of overseas corruption that haven't been mentioned. So in the Greek healthcare market, for example, a prosecution of an individual, and certainly the insurance sector, the prosecution again of Julian Messent. More generally, in a commercial bribery context, the Operation Navigator case is one that some people might be aware of, the prosecution of a number of people for a quite serious case of commercial bribery, and then finally again civil servants and commercial people in Northern Ireland prosecuted recently. So the context is, I think, slightly greater enforcement than the introduction, and I think the expectation is that with the advent of the Bribery Act, we certainly have a legislative scheme that allows us to concentrate more clearly on corrupt activity, as opposed to in the past necessarily having to deal with complex questions of jurisdiction and the like. And so, if I would, without necessarily going into the details of individual cases and how many, that broadly I think is a fair reflection of what we have done and what we will be doing.
It was said by the new director that the SFO is here to stay. Of course, there was some room for doubting that over recent years, given the criticism that was levelled at the SFO. And it will remain a key crime-fighting agency targeting top-end fraud, bribery and corruption. It's suggested that the budget that you have to deal with corruption is wholly inadequate. It's suggested by some NGOs that the figure that's available for bribery and corruption is some £2 million. There are those who point to the immense undertaking relating to the Siemens investigation and the manner in which Siemens was able to amass a vast amount of information in the various jurisdictions, 20 if I recall correctly, where it's under investigation. And it accumulated fees of in excess of $100 million. Now, if that figure of £2 million is correct, how does the SFO propose to target top-end fraud, bribery and corruption if its resources are as limited as being suggested?
I think one thing we ought to recognise from the outset is that we're not alone in targeting top-end corporate corruption. We form part of a government coordinated response to dealing with this. The OECD has recognised that the UK's approach to enforcement of overseas corruption is in the active category. The Financial Services Authority, the City of London Police and the Metropolitan PEPS team all do a very great deal of work. And so focusing, I think, immediately on a precise figure available to the SFO is not necessarily the most informative way of understanding what our approach to corruption is as a government as a whole. The Abori case is a classic example of the effectiveness of other parts of the state in dealing with this. More generally, we're not alone in dealing with a reduced allocation of funding. It's something that is a reality for most government organisations. And again, I'm going to confess to not having come prepared with an exact figure of the amount of pounds sterling available. I don't necessarily expect that we don't have the resources for the job, is the short answer, and to focus on figures doesn't really, I think, understand the approach that we adopt more broadly.
I should emphasise that, of course, the purpose of the session is to invite all of you to participate and comment. And questions, insofar as they're addressed to a particular speaker, are addressed to enable us to understand the topic that we're discussing more clearly. And perhaps it's a little unfair, but equally unsurprising that these are questions that are directed at the SFO.
Can I just help Satnam out? I'm Sarah Newman from the Attorney General's Office. I'm the Deputy Director of Strategy and Finance there. So I can help Satnam out a little with the figures. The overall funding for the Serious Fraud Office over the last few years, it has decreased in line with government spending for all prosecution agencies and indeed all departments, but it's around the 30 to 35 million figure.
That's overall.
That's overall indeed. I can't tell you how Director decides how to split that between fraud more generally and corruption. So I'm just giving you an impressive list of cases which really focus more on the bribery and corruption side over the last few years, from which I think you could probably extrapolate that it's probably more than 2 billion out of the overall budget of 30 to 35 million. So far as I can assist, I can give you an idea.
It is very helpful. Can I make a mention?
Yes, of course.
It's very helpful. We've got obviously a senior law officer here, very nice Solicitor General you can attend, and also representative of the law officers as well. I think it's pretty important that the Serious Fraud Office, if it is going to be true to its new director's recent pronouncements, that it should be very clear that this organisation is really here to stay. Now, I may be wrong, but my understanding is that the new address for the Serious Fraud Office will, after the Olympics, be Cockspur Street in Whitehall. So I don't know how long the lease on that property is, but it doesn't strike me as, if that is true, as Cockspur Street being a particularly great location for the primary corruption crime-fighting organisation of the UK. And I think if that is the case, something ought to be done about it, and the SFO ought to have a decent building in the centre of the financial district of London, from which it can conduct its very important business.
May I just add in one other point or two?
Yes.
I'm just building on it and actually saying that the question is ultimately not a legal one, but a political one. And it's a political one which addresses the issue of resource. And my observation over the last few years of successive governments trying to deal with issues of systemic corporate bribery and corruption and fraud is not one, now we've got the Bribery Act of 2010 in place, of the absence of regulation and the absence of statutory basis to enforce, but it's the absence of the ability of the state to fund those who police the enforcement and then prosecute it properly. And one only has to look at the vast press coverage of going on in Leicester, which isn't at its heart revealing anything to do with the absence of all of the available legislation to prosecute the criminal offences, but it's the inability to properly investigate or prosecute, and the same is now true with the banking sector and the scandal that's happening around LIBOR and people effectively being asleep on their posts. And the same, in my view, as a defence lawyer, is true of the SFO. And frankly, a budget of 30 or 40 million pounds to prosecute, whether it's 2 million or 4 million pounds available to prosecute these matters, given the huge resource available to the private sector to defend when it wants to these investigations, is lamentable. And what it takes is the political will to fund the resource to properly investigate and prosecute and bring these offences to justice.
So I was going to say the other issue is just in the investigation of fraud more generally, this inability, I don't know, I'm looking at it, but I will, inability to have a national fraud squad police service, which should exist out of the City of London Police and support the SFO and the CPS and other agencies. It is time that things move on, because there is a postcode lottery in the UK. We do lots of corporates located in different locations, and okay, if you're in the City of London or in the metropolitan area, more likely that you're going to get the interest of the police to assist. But outside, in places like West Mercia or beyond, impossible. There isn't the skill base amongst police officers to go and investigate crimes which should be investigated, and there are fraudsters who are being able to effectively laugh at the system, and all we're doing is scratching at the surface. I think when recently, I'll plug it anyway, Eversheds has done a survey which came out yesterday in relation to frauds, and we talk about a £73 billion problem as far as the National Fraud Agency is concerned, but 157,000 cases actually reach the courts or are investigated, out of which 40,000 roughly result in some form of sanction. And if you compare that to the 73 million figure, you look at the level of cost in relation to those that actually are successful. Something like 0.4% result in a successful climb, a successful conclusion, which tends to support the fact that clever fraudsters can deal with it. The other thing that we've seen as a firm is that law enforcement get very nervous when it's cross-border. So if you're dealing with a corporate that is suffering from cross-border fraud, so a fraudster sitting in one jurisdiction and committing crime in several others, then they will often say it's too complicated, too costly and too difficult to deal with. And the companies are really left to their own devices to try and asset trace and do other things through the civil process. And yet people are getting away with effective fraud to many millions of pounds.
Right. I think one of the difficulties that has arisen as someone who's currently prosecuting a fraud, and I defend more than I prosecute, but one of the eye-openers really is the way that it's dealt with separately. And one of the issues, to a certain extent, having an office or a regulatory body gives that perception that fraud is something separate. And I think we've reached a point now where we don't really have what I call victim-led justice in relation to financial crime. It's all about following the money rather than following the victim. So, for example, as I understand it, we have a system in relation to quite minor fraud where people can phone up and report to a hotline called Action Fraud. And those phone calls don't, as I understand it, go into the criminal statistics. They're just an intelligence base where we can find a hotspot and then look at a particular hotspot, as I understand it. And I think one of the things that can be done is for the Serious Fraud Office to be able to work more generally with the police force and that investigation has to be down to the lowest possible level. It's a bit like the old police officer in Middlesbrough that went in and dealt with the little things that build up to the big things. If we get back to sort of basic principles of investigation, then it encourages those who have a duty to investigate to look into financial crime in the same way as they look into any other sort of crime.
Sorry, let me just, I hadn't thought I was going to take part in this part of the discussion, since I've been definitely have a go. First of all, I think it's important to draw a distinction between the sort of work the Serious Fraud Office does and the sort of work that even the Metropolitan Police but other provincial police forces are doing. The Serious Fraud Office is not after the butcher, the baker, the candle, the baker. They're dealing with high-end, complex, and very often international corruption, fraud, and other forms of economic crime. So they should not be distracted in following you to Mold Crown Court, and much of that would be interesting, to deal with what stuff it ought to be dealt with by David Police or whoever. We don't, and we haven't historically, for all sorts of reasons, prosecuted what I call that middle range, the bulk of fraud very well. The serious fraud has had its ups and its downs, but it concentrates on a narrow band of high-end white-collar crime. Where we, I think, have gone very badly wrong because the priority has been adjusted, and it's because we successive Home Secretaries over the years, I'm not being a part of it, but successive Home Secretaries over the years have had to, or felt they had to, follow the pressure of particular headlines. Clamp down on this, clamp down on that. And as a consequence, with a limited budget, police forces have adjusted their focus onto drugs or to antisocial behaviour. But in the meanwhile, lots and lots of people are being ripped off by lots and lots of pretty effective but not high-end chaps. We do need to get that right, and we do need to do it better. But that's a police function, it's not a Serious Fraud Office function. The Serious Fraud Office is an SSO, here to stay, and is here to stay with vigour. And if you want to take us on, make my day, because I can assure you, the new director and the new political drive, which is, I mean, Dominic Green and I have not wasted the last 2 years trying to stop it being subsumed into something else in order to see it do nothing. The Serious Fraud Office, and Satnam is an example of it, are highly dedicated and are in the business of bearing down on deterring, but also investigating and prosecuting the villains. My interest in deferred prosecution agreements is not to say we will do nothing but do deals. It's to provide an additional way through to deal with crooks. And some crooks will be prosecuted, they will be taken to court, and they will be convicted, and they will be sent to prison. The sentencing levels will go up. Some criminal cases will sensibly be dealt with by deferred prosecution agreements or other sorts of settlements. And other forms of termination won't lead to any prosecution at all. It's something either the evidence or it's on the public interest to do. But I think we have to separate the serious fraud office from the bulk of white-collar crime, which ought to be prosecuted by the CPS and investigated by provincial police.
I think maybe I was slightly misunderstood. I don't disagree with that at all, and I hope the serious fraud office is here to stay. And of course, what we're talking about today is, I think to use your words, cleaning up corporate business. So we're not talking about general fraudsters who are of themselves just complete criminals. These are businesses, one hopes, set up legitimately and then involved in corruption. So it's a slightly different topic. But I think the point that I was trying to make is we currently, certainly after libel, we have a situation where there are members of the public that are perfectly happy for ordinary businessmen to be hung up by the balls and dealt with in a public court. And I think the perspective that I come from here in relation to any sort of plea bargaining or deferred prosecution agreements or, frankly, in-chambers hearings is that prosecutions, in my view, or defending an allegation, in my view, is really a matter for open justice so that it can be approached in that way, whether it's high-end, multi-million-pound international jurisdictional fraud, where police organisations or fraud office organisations can interact and interrelate and cooperate across the world, or small individual police officers dealing with small individual businesses. I think the perspective that we have to have still has to be something to do with open justice that the general public can understand.
Does anybody in the audience want to comment, have any observations? At the back, if you could just identify yourself.
Certainly, I'm Caroline Brennan from the Financial Times. Edward, you made a very quick mention of sentencing going up as part of that, and I was just wondering if you could elaborate a little bit.
Well, obviously, I don't sentence anymore. I have to stop that when I became a minister. And I don't think our constitution quite allows for me to sentence people, although it's been interesting to develop. I think it is widely understood amongst the public, but also those who comment on it, that by and large we tend to under-sentence white-collar crime. And partly that's because nobody gets hurt. There's no blood, no broken bones. And I've always taken the view that the man who goes into the front of a bank with a shotgun is no more or less reprehensible than the man who siphons the money out the back through a computer. People are hurt by this form of thieving, and the courts need to deal with it. One of the things I think that is going to get home is that criminals who steal huge sums of money in a sophisticated way are no longer thought to be clever heroes. They are just villains. And they shouldn't be given 2 or 3 years in 4 days of prison where they can run a drink concession. They should be given sentences which are warranted by the criminality that they are guilty of. I think the judiciary are beginning to think that the sentences are too low. Well, we've seen insider trading, I can't remember the name of the case, but it took 11 years the other day for a white-collar crime, which would have been unthinkable, I think, 2 years ago. Clearly we're not moving into the American system where Madoff gets ludicrously stupid 150-year sentences, Stanford gets whatever he gets. But I think there is a judicial and a public, and I think a commentariat appetite to see justice being done in a rather more forceful way. We will see what happens in the libel issue. There's some awful allegations that have been made, but they will need to be investigated and sorted out. As regards the resources for the serious fraud, the Prime Minister is on record saying that the serious fraud office will have the resources they need to do the job. So I think anybody who thinks that we've dropped the catch on this is an advantage. Can I just make one final point? Peter is a man who I've offered several knighthoods and dukedoms to over the last year, and all sorts of reasons. But I say so, his point about the address for serious fraud is probably one of the feeblest I've heard. And if he's advising any of his clients who might be in the frame, that they can relax because the serious fraud office has an address called Cockspur Street.
Can I just raise something, just to come back on this idea of a national fraud squad and the capability of dealing with those middle bracket cases, and just to show the sorts of stuff we're having to deal with, because we're dealing with corporates who are experiencing what we would describe as levels of fraud that come well within the remit of the SFO and certainly within the remit of the CPS fraud unit. Very good example, which was something I raised with the SFO and with the City of London, couldn't get their interest, was a case in West Mercia involving a £4.5 million fraud. We had undertaken an internal investigation, we'd uncovered it, we even had, and it was sent quite by chance, a confession letter from the perpetrator saying basically, I'm really sorry I stole all the money from the business, I've got a gambling problem. He did have some assets, and so we froze those assets and seized them. And the result from West Mercia, who at the time had 3 economic crime officers, I don't believe they have those 3 anymore, I think they may have none, was, well, you've sorted out civilly, what's the problem, basically. And then we couldn't get any interest from anybody else. It wasn't the most complex fraud, and certainly I wouldn't put it into the SFO, but CPS certainly. But the result of it was that this individual got away with it effectively. Yes, he was poorer at the end, but who knows where he's working now. And he doesn't have a conviction for actually a very serious crime. And so that is an issue, and we see it more and more, and I'm sure those who do investigations see it all the time. It is a lottery as to which cases are taken on and which cases aren't, and clients struggle with it. And this particular company had an American parent, and I can't tell you what the American GC had to say about our judicial system. She found it inexplicable that you could have a situation where somebody walks away with millions of pounds, and law enforcement said, oh, you've got the confession, all the evidence, but actually we don't have any officers, so sorry about that. Good luck.
I think that's the point I was trying to make earlier on, really, is that there has to be a system whereby it is picked up by an investigating authority and it is allocated in some way, not treated as something separate. Just to come back on the point about people being heard, in the financial cases, I'm sure we all read on a regular basis, we could all give you a story about somebody who's been very significantly hurt. So it's a question. I agree with the difficulty of getting somewhere to pick it up, and I think to a certain extent the perspective is that financial crime is something different.
I think it's important to at least recognise that there are attempts made to what we would call orphan cases. The National Fraud Authority is a key part of the proposed National Crime Agency, and a focus on economic crime is obviously something that is expected going forward, and work has been done in this regard. Now, it's not an issue that we're unaware of, and as a government not dealing with. I mean, that's part of the UK's approach to combating fraud. Part of our role is to make sure we're plugged into that in the most effective way and facilitate the work of the economic crime command of the National Crime Agency, and we do our part in making sure there are less of the orphan cases and that people understand what the SFO is here to do, and we facilitate where possible the uptake by others within the counter-fraud community of their role in it.
There was mention made of sentencing, and some people in the audience may be aware that the first successful conviction under the new statute was of the court clerk who decided to try to prevent a motoring offence from entering the court record. That was a matter that was revealed as a result of investigative journalism. He was sentenced to 3 years in prison for corruption, 6 years for misconduct in public office, reduced to 4 years on appeal. And the appellate court made it absolutely clear that corruption was going to be treated very severely and seriously by the courts when it came to sentencing. Mention has been made of the American experience. and the limits, the suggestion that we shouldn't be sentencing people to several life terms. But what more can we do, or should we be doing, to enhance the role and capability of the SFO to deal more robustly with top-end fraud, bribery and corruption? Susannah, any thoughts?
Well, I think on the sentencing question, one of the interesting points is where fines are going to go post-innospec. Of course, in that case, the judge imposed the sort of agreed $12.5 million on the basis that the company would otherwise have gone insolvent, also the evidence suggested, and various other factors which were peculiar to that case, but also indicated that the expectation was that in future cases, fines would be more comparable to the US level. Now, since then, in terms of corporate convictions, we've had BAE, but of course that was for a Companies Act offence rather than actually for corruption. And of the 30 million which BAE had agreed to pay, as many of you may be aware, that the judge ordered sort of 500 grand of that should be by way of fine, and the remaining 29.5 million was to be paid by way of compensation to the people of Tanzania. So really what we are still awaiting post-innospec is a corporate conviction for serious overseas corruption to see whether it is correct that fines are going up or not. And I think that is important, and there's a suggestion in the DPA consultation that there'll be a sentencing guideline by the Sentencing Council, and again that will be quite important for companies in terms of working out whether they will engage in the DPA process, whether there's sufficient certainty to do so, whether there are sufficient incentives to do so, and indeed for companies generally, regardless of where the DPA proposal gets to, in terms of deciding whether to self-report. Because by comparison to the US experience, at the moment, and again I come from this from a perspective of generally representing corporates who are often trying to decide whether or not it's in their interest to self-report and to determine what their liability profile would be. In the States, you have a genuine fear of corporate prosecution because it is easier to prosecute corporate entities, and you have a genuine fear of the outcome if you get successfully prosecuted because of the level of penalties. Here in the UK, corporate offence under the Bribery Act aside, and perhaps we'll come on to that, it is much more difficult to prosecute companies, and the fines have traditionally been much lower. And that is, so in kind of carrot and stick world and persuading corporates to come forward and so on, there's not very much stick to hit them with comparatively, and frankly the carrots aren't all that great either. So in terms of the SFO becoming more effective, actually I think a key part of that will be where we go in terms of sentencing levels, and again a wider question of where we go in terms of corporate criminal liability and any reform to the sort of directing minding world identification principle.
I think that's an extremely good point, because I think one of the difficulties with the DPA proposals is precisely how attractive a carrot that process would actually be. And one view, of course, is that it won't be that attractive, because companies will, in a very public way, for Caroline's benefit, have to appear in court and have everything clearly laid out on the website the day afterwards or the same day to explain precisely what criminal conduct they've admitted to. Now, at the moment, and in the last 5 years under the previous director's reign, there was great considerable effort made by numerous lawyers, paid no doubt a great deal of money, to persuade the SFO that really they didn't need to prosecute the relevant company, that they could enter into a convenient settlement based on the books and records offence under the Companies Act, which frankly no prosecution previously had never really bothered to use, and it also didn't really fit the conduct that was being settled, if you like, anyway. But nevertheless, that's what happened. Actually, I think it was a pragmatic policy to take. It actually drove things forward, and of course brought us to the DPA position. What I would be concerned about is that we adopt a DPA process which is too Americanised and is actually, frankly, becomes a drag on the economy because of the sheer scale of the potential damage that can be inflicted on companies, including monitors and all the rest of it. That in America actually hasn't been a completely happy experience at all. So I'm not convinced that companies will be queuing up to come and enter into a UK-style DPA if the carrot really doesn't look sufficiently fresh and attractive to bite into.
I think there's some sort of evidence to support what Peter's saying in terms of the use of, which the SFO, I'm surprised I haven't mentioned, the use of Part 5 settlements in the Citizens of Crime Act and the extensive inflation. I think they first came into effect in 2005 with Balfour Beatty or thereabouts. And I mean, the only information available to the general public on the use of Part 5 settlements is on the SFO website, or what journalists manage to sort of glean, generally speaking. But the inflation from Balfour Beatty of about a £2 million settlement up to last July of the Macmillan settlement of £11 million is really very considerable. And one of the things that, from a defence lawyer's point of view, is fantastically attractive is that this is all sort of done in behind closed doors without any judicial supervision at all, other than it's safe for it's presented to the court as a fait accompli. What the attractiveness of the DPA model is precisely the bit that Ed was just mentioned in terms of imposing a judicial settlement and judicial supervision of what's going on. And I think the balancing act between the sort of UK PLC interest not to have everybody's dirty washing sort of unveiled in public, and also the need for sort of justice to be done in a transparent and open setting is an interesting one. And we've got the two examples competing side by side of Part 5 and the DPA models. And I think whether or not the note that you're striking in the proposed DPA legislation is the right one, taking on board what Peter said, is an interesting area. But for me, as a matter of sort of with my public policy hat on, it's definitely the right direction of travel.
If I could just say on civil recovery, and I thought it was quite interesting for those of you who haven't yet read the SFO press notice in relation to the OUP settlement, Oxford University Press, a week or two ago now. They actually published the application notice, the order, and the claim form, I think, for the first time. So you had and a list of reasons why a civil settlement was thought appropriate in that case. So there's clearly been some response to the concerns about the transparency of the process, although I think it remains to some extent. And the other fundamental difficulty with that, of course, is it's not legislation which is aimed at punishing companies in this sort of scenario. It's legislation which is aimed at depriving wrongdoers of the benefit of criminal conduct. So you could commit or have a subsidiary which has committed quite a severe criminal act, but if there's no benefit flowing up to the parent, then in theory there's no scope for a civil recovery order, and therefore at the moment you're stuck between probably being unable to prosecute if it's the subsidiary's conduct and not having scope to enter into civil recovery. So I think that there is, sorry.
No, go on.
Yeah. So I think this is slightly rambling fashion, I'm trying to say, and I think there is a place for an alternative mechanism which may or may not be the DPA or maybe a modified element of the DPA. There's probably a role for civil settlements still as well, but those may need to be adapted because I don't think the current Process of Crime Act procedure or mechanism is really a complete answer to dealing with corporate offending, particularly in the corruption space. I have to agree with that. One of the major problems when you're an advocate in a criminal court is fitting the conduct that is discovered during the course of an investigation into a particular statute or count on an indictment. And sometimes you can have rolling conduct cross-jurisdictional that you just struggle to fit into existing legislation. So one of the difficulties, it seems to me, with the idea of whether it's plea bargaining or DPAs or some other hybrid criminal civil process, if that's what we're talking about, is that you, in order to make any such agreement, the difficulty at the moment is we have such disparate statutory legislation that it's very hard to fit an agreement into what the fraud is. So there's a knock-on effect in terms of statutory legislation if you're going to be looking at.
I think you'll never get up in the morning if you go like this. I mean, this is an addition. It's not just a replacement. It's an addition. And there will be occasions when you'll be prosecuted. There will be occasions when the evidence simply doesn't stack up and nothing happens. There may be occasions when several recovery orders of some description are the appropriate way forward. But here's an additional way forward, which I think is well worth looking at. And do bear in mind there are 3 letters in DPA, and A means agreement. Nobody's forcing you to come and agree with the direct and serious law officer to do this. Nobody is forcing you to torture facts into a false indictment. If the facts don't constitute a criminal offence, well, there's nothing to reduce the facts into. So we'll all have to be quite grown up about this. Because we haven't done it before in this jurisdiction, of course it's nervous-making. We're all having a degree of fear. We're edging towards the diving board. But I can assure you that there's a lot of cold water down there, and if you want to dive in and get prosecuted, you go ahead. Because there are judges and there are courts and there are prosecutors who are very willing to, they've got the evidence to push you through.
Well, can we just have a quick suggestion on that one? Sorry, someone's going to have.
Yes, if you just want to.
Mr. Banks, Head of Business Law at the Institute of Chartered Accountants. So I'm looking at this from the point of view of companies, as well as prosecutors and lawyers. And if you don't think you're going to have a chance of being prosecuted, you're probably going to go on doing your core job, which is serving the interests of clients. It is in the interests of companies, the economies, as well as justice in the UK, for there to be some more order in corporate crime in general. For some crimes to be committed, to be organised under the Bribery Act system, everybody knows where they are. But with other corporate crimes, which depend on the directing mind of the corporate, you're not going to get anywhere apart from the tiny crimes. Wouldn't it be better to sort out the law on corporate crime in general, in parallel, if not ahead of, doing work on prosecutions?
That's fine as a matter of senior common room debate, but actually politics is rather less complicated, in fact more complicated. I can't do everything at once. I have a 4-year parliamentary slot, or 5-year parliamentary slot. I must do with the information that I have, the weapons that I've got, what I can. Yes, of course, I would like to see the British, English law of corporate criminal liability brought more in line to the essentially the vicarious system of liability in the United States now. That the fact that we have a different system of corporate criminal liability on one side of the Atlantic as compared to the other creates problems. And yes, of course you're right. There will be some companies who say, well, the directing mind can never be proved, so therefore let's carry on doing our criminal activities. We'll get away. Well, the Americans will get to it, even if we don't. And you need to think about that, because the American reach is very long. But secondly, we will enter into discussions with them. We do already with the Department of Justice. And I can assure you that the corners are going to be blocked off, the exits are going to be blocked off, one way or the other. The life of the international criminal is going to become a lot more difficult because, frankly, the public have got bored of it. They see all these big numbers sloshing off down the drain, and there is no public appetite to allow people to go on like this. So I think we all just need to realise that there's a change of culture coming. There will in parliamentary terms, be a delay in marrying all this up. But I will take one step at a time, and I will catch villains, and I will let off the innocent, and I will do what is appropriate, and I will do what is just. But just because it's difficult, just because it takes time, doesn't mean to say that there isn't the political will that people were asking about. And I don't care which address I'm doing it from. I'm sure we're going to do it. So let's get ready for it.
This is a question just drawing together things that I'm hearing. Peter was saying that there isn't much of a carrot for people to self-report, and I've heard other people say that actually in a lot of self-reporting cases they thought they were going to get caught anyway, and so they just came forward to try and get them credit. And in terms of the SFO press release on Oxford Publishing, a lot of the reasons they seem to be giving were the fact that they couldn't have prosecuted because the way the evidence was inadmissible, or they didn't have the resources and couldn't get the witnesses. And just drawing those sort of 3 things together and looking at bribery offences, does it seem unlikely that anyone would ever go for a DPA on a Bribery Act offence because you've got a Section 7 offence, which means that they can say, well, there's even a sniff of evidence here. The onus is now all on you to show adequate procedures. And why would the public be interested in a DPA or be in favour of DPAs if people started getting DPAs in that situation when actually they could have been prosecuted? Because the legislation, the Bribery Act, is so different from all this control of mind and will kind of requirement.
And I think it's quite interesting, and it depends a bit on where we end up in terms of the adequacy of defence, because it seems to me there will be some cases where a company has paid, or a bribe has been paid on a company's behalf, and their procedures were clearly on any view inadequate. You know, they didn't have a policy, they hadn't bothered to train anyone, it's all completely hopeless. And in that case, you might say, well, it's a slam dunk on a corporate offence. If they think it's going to be found out, the DPA is actually pretty attractive. In other cases where actually they have a arguably reasonable compliance programme, but maybe there's some holes around the edges which might not be regarded as best practice, there's going to be an interesting question in terms of how willing or eager people are to test that in court and say this is adequate, and how easy it's going to be for the prosecution to prove it's not adequate in terms of its practice once they put it in adequacy, etc.
I'm going to say that from the corporates that I deal with, there's no way if they can do something that prevents them being solid through the court process. And so, in the event that you're going to have the standard SAR reports going on, there's the likelihood, there's a whistleblower, there's a journalist involved, and then Caroline's sitting around from the FT, there's a worry. If they can get comfort from the fact they can go and speak to the SFO, in a way that Richard Alderman introduced, and you can have tea and coffee and a sensible chat about what the business should be doing, and on top of which the business has to finance its own investigation and support potentially the SFO in investigating and prosecuting individuals, then I would have thought it's a slam dunk that they would be interested in doing it. Add in the sort of international fear that's going on at the moment, and a really increased interest in bribery and corruption worldwide, particularly the US, but other states now, including Russia signing up to the OECD convention and others coming round. I think that, from my perspective, I can imagine lots of clients, anyway looking from the corporate side, biting a hand off for anything that prevents them being solid in the way that the prosecution directly would, as Edward said before, in relation to other aspects.
I entirely agree. I think you're most likely to get people coming in and doing a DPA in relation to the corporate offence, and it will be attractive for some companies.
And actually, if we look at, say, a massive corporate international, the ones that SFO would love to get, the reality is those companies, the household name companies, will have wonderful compliance reviews. Susannah and me and others, to go and look at them and audit them and talk about third parties and their risk in Iraq or whatever they're doing. But if you've got 40,000 staff worldwide, things can go amiss, and you can have divisions that do things that doesn't represent actually the ethical nature of the business. And to that I can sort of see the advantage of this type of thing where it comes in. I can see some issues with it, but I can also see corporates being very excited about it.
But you think on the flip side of that then, we'll end up in a situation where, like in States, there's a dearth of case law about what these things mean, because everybody just makes an agreement rather than ever, so nobody actually will ever know what adequate procedures actually is, because no one's ever going to take a case to court.
Right. I think it's going to be the case that they don't have anything, or they have one silly policy and they don't have proper training, and it's it's a slam dunk approach. But if you're the SFO, you're going to want to use your resources adequately. Why are you going to go after a major PLC where, as their expert witness, they're going to have someone from Herbert Smith or from Eversheds saying, well, actually, we've been in and we've audited and we've done this, and yes, we've advised, because they're going to shy away from that. They're going to go for the low-hanging fruit. On top of which, if you get the corporates on side, then actually they're going to be able to do some privatisation of that process. Now, corporates don't like it, but...
Could I just deal with a few of the issues, or quite a few? On the sentencing point, we've moved on to corporates, and I'd just like to touch on individuals. The Tariff and Bribery Act is 10 years, not 7, so I think there's a perfectly sensible expectation that it's viewed seriously, and there was commentary in the Court of Appeal before the Lord Chief Justice on the sentencing of Dougal, which is, I think, again, something that gives weight to that point of view. The OUP settlement is envisaged within the Attorney's guidelines on the use of Part 5, that if we are unable to bring in criminal prosecution, it's a perfectly sensible use of Part 5 of the Proceeds of Crime Act. Self-reporting, It may be that the dialogue we're having now about deferred prosecutions is a dialogue that might have taken place 4 years ago about whether or not companies would be ever interested in self-reporting. OUP and others are good examples of the movement we've had over the last 4 years, and I certainly do expect a very, very helpful introduction of DPAs to the tools that we will have available to us. And then finally, as to whether you'll get a dearth of key jurisprudence around the Bribery Act, I think it's important to recognise that we have a history here of prosecuting individuals and of dealing with difficult cases and taking those to court and getting answers. Sometimes we make mistakes like any other prosecuting agency, and a decision that gives rise to jurisprudence is not one that we would necessarily agree with from the outset. But maybe in Johnson, in a spec, are examples of individuals being brought before the criminal court, and I think if you look at the evolution of the Foreign Corrupt Practices Act and some of the unease that Peter was talking about, you probably understand it in that context, and I don't think it's quite the same here. Finally, deferred prosecution agreements on the consultation table at the moment look very different to the model that's used in the United States, and I absolutely welcome them. And as somebody who's worked in the SFO 17 years, again, perfectly well envisaged circumstances where they would be abusive.
I think one thing that we all have to realise is once you take the step with DPAs, whether you like them or not, and certainly after LIBOR, I think people will quite like the idea. And I've perhaps mellowed on the idea a little since I faced the a little, only a little. But I think to answer your question, you are probably going to have fewer prosecutions. The reality is you're not going to get any jurisprudence. There's not going to be anybody hung up by the balls, to use my expression earlier on. Very few public procedures, because if you, in relation to what we've been calling corporates, the words, you've heard them, slam dunk. They're happy with that idea because they don't want to go to court. And certainly in terms of the public purse and so forth, if you've got an agreement that can be workable, then from a court perspective, it's very unlikely that you're going to be seeing indictments and prosecutions and companies being subjected to public scrutiny. And once you take that step, judicial scrutiny may be on this proposal, but it's not going to be the same. And we can take America as an example. There were very few cases compared to...
Can I make a point about that? Sorry.
Yes.
The plain fact of the matter is the government recognised and brought the Bribery Act into force. The regulatory impact statements say there will be literally a handful of prosecutions a year between CPS and the SFO. There's nothing wrong with that. What the BAE case actually did, just the investigation, changed corporate culture in this country forever. It changed it. Even if BAE had not been convicted and had not had to pay its paltry UK fine, etc., it would still have had that effect, because the mere fact of investigation is often enough to change a company's attitude and change the individual's attitude within it. So I don't think anyone should run away with the idea that just because we don't get convictions, that is necessarily a bad thing. Yeah, investigation and publicity, and hopefully we'll still have a free press after the medicine inquiry is finished, but all that is about corporate accountability, which I think is on an upwards and really sort of apparently never-ending trajectory. And the Bribery Act is just one part of the process by which the government tries to ensure and deter criminal conduct, in this case obviously corruption. So I don't think the fact you don't get many prosecutions actually makes that much difference.
Well, I think one of the things is crime prevention has always been about education, and any of the parties that you go to, the International Bar Association conference in Dubai last year, all the big lawyers from across the world were all there talking about how they could make money going into companies and educating companies on how to avoid the Bribery Act. So I agree, companies have been educated in relation to the legislation, and that's why we don't get many prosecutions, but you're not going to have that sort of policy.
I suspect you mean how they could ensure that the companies comply with the
suspect I do, yeah.
But it's what we're hearing here, the importance of ensuring a balance, it's a delicate balance, enabling UK PLC to continue to conduct business, there's been considerable criticism of Section 7, the corporate offence of failure to prevent bribery by persons associated with a company, and the definition of associated provided by Section 8, performing services for or on behalf of a corporate entity. And we have Section 9 guidance issued by the Ministry of Justice in March of last year, 6 principles, the main one being proportionate procedures, one suspects. The question for the panel, and anybody else who wants to answer this, is have we struck the right balance? Is it too onerous on UK PLC? There are some who say this is handicapping and impairing the ability of UK PLC, UK businesses to undertake operations in jurisdictions where, particularly in a very difficult economic climate, there are other states that are also possibly signatories to the OECD Convention, where they seem to have less problem with their nationals and corporates, it's said, paying facilitation payments, which are also prohibited under the Bribery Act, let alone payments to seek, secure an advantage, an improper performance of a function. Is that balance correct?
Well, I was just going to just make one point, which Neill's going to hear, which is that we are now being instructed to assist corporates who don't do any part of their business in the UK in developing a compliance regime that meets the standards of the Bribery Act. So it's created a benchmark internationally. And I might have taken that view back in March 2010 or 2009 when a bribery bill first surfaced, but the reality is there's a massive impetus worldwide, and there are other law enforcement agencies in countries like Australia now, and Hong Kong, and Germany, and the UK, and the United States who will target and go after corporates for activities that go on. So if you're an international corporate, quite frankly, you can't get away without having some form of ability to monitor and minimise the bribery risk in your organisation, because you're going to get caught out in more than one jurisdiction and it might be extremely painful. There's always going to be an issue about being undercut by local companies that haven't got the international reach. But ignoring those, Bill, you've seen something.
Yeah, sure. And I think there's, I agree entirely that there's increasingly international companies seeking advice on Bribery Act compliance, but part of that is based on a feeling that the Bribery Act will be enforced. And I think it will be important, and I take Peter's point, it's not just about convictions, but I think it is important, if that trend is to continue, that there are at least public investigations into Bribery Act offences other than, and particularly corporate offence, other than the court clerk. And I mean, Richard Alderman was previously on record as well as saying that, you know, the SFO would not shy away from the difficult jurisdictional issues, for example, that Section 7 gives rise to, from the difficult cases in relation to associated persons, etc. And again, it's going to be, I think, relatively important to see some cases that test the boundaries of the Bribery Act if it's to continue to be an effective tool in driving corporate behaviour, otherwise we'll drop back to
as well. The minute they have the first report of a conviction, or indeed actually a charge in relation to it, phone Smith and Eversheds and lots of other firms around the city's going to go off because all these people are sitting around are going to get their chief execs bringing them in compliance or illegal, saying, what the hell have we done? Oh, we covered, we need to know we're covered. So they don't need many, do they? 1 or 2 cases a year, that will
Mine is just a very brief point. I think in general I agree that the balance is if it's not there, we're moving in the right direction. However, there's a whole class of individuals that we haven't talked about, and that is the individuals. And I think the tendency and direction of travel of the legislation is to throw a lifeline, maybe arguably a good lifeline, to the corporate entities to enter into a DPA or a Part 5 settlement, or to have adequate procedures and throw the individuals under the bus and allow them to be prosecuted, either without the benefit of a D&O policy or with some paltry legal aid, which very few firms, including this one, Eversheds, would do it for.
Yeah, but I mean, you know, fine. We're representing the corporate, we want to see them through the process. If we've got some corrupt individuals, then fair enough.
It looks like there's a consensus here that everyone wants a head on a pike proverbially, after due process, of course. In terms of the way forward, are there some parallels with the way in which the business community reacted to insider dealing? As the Solicitor General pointed out, we had the famous Guinness trials where everyone was saying 20 years ago, when I started practice, there was nothing wrong in what they were doing. money laundering, which was seen to be extremely difficult to prosecute. Then we had the Proceeds of Crime Act 2002, which introduced the offence, the compliance industry that was generated and well fed as a result. And now we have the Bribery Act 2010. Is the fact that the first ever conviction for overseas corruption took place in 2009, maybe in Johnson, and since then it's possible to suggest that there's been a spate of investigations, charges, convictions at the behest of the SFO? Is that indication that the Bribery Act 2010, whilst initially subject to considerable resistance, is now bedding into corporate life, corporate structure? Peter?
I'm afraid I think it's far too early to tell. And that's my view.
I think it is, and I think that the average business that certainly has international reach is very concerned about issues of bribery and corruption, and those issues have been, have surfaced because of the fear around the Bribery Act, and that was because senior people in the businesses actually were willing to start resourcing and looking at it because of the fear of corporate prosecution. So if you can get that right, if government can get it right and create a fear factor, it's that fear factor which will bring business round and will create better ethical standards and also support law enforcement, because they will support law enforcement in what needs to be given. I did want to ask one question, and it may be obvious, and certainly if it's a thick question, but it's one for everyone and others. If we could get civil recoveries working properly, I was aware there's provision which allows, is it up to 30% to go back to the law enforcement agency. So why can't we use these tools? And you've heard from me, and Susannah's backed it up as well, in the corporate law space, we do corporates all the time. And the reality is, companies will enter into these arrangements to avoid prosecution. So in the right cases, 30, 40 million pound cases, this could be an avenue, surely, to help fund the SFO to do what it should do and act in a way that it would like to do if it had the resources to do it.
This is not something I haven't thought about.
Well, I think you're right. Personally, I think Part 5 is more attractive than the DDA.
Yeah, yeah.
But I actually question whether we should have DDAs at all, when we've got Part 5 which could be adapted in a way that Susannah was saying. So not to decry the DDA idea, but it could actually be modified into an existing piece of legislation which could quite simply be amended, and I think that would be more attractive. And there's always been and in the Code of Crown Prosecutors, there's repeated the maxim that in public interest, you do not have to prosecute every case, and you plainly don't. There never has been that rule, and there ought never to be. We settle cases in other kinds of conduct every day, in export control by compound penalties, in tax, VAT by compound penalties, or civil settlement in the revenue. Those are not the subject of public court hearings. So in many ways, I think, the experience with the Part 5 settlements has been a good learning experience. That legislation could be modified. I think it would be more attractive overall. And it would still allow the SFO to decide, well, actually, no, you're not going to have a civil settlement because it's too serious, you weren't going to be cooperating, and in fact, we're going to prosecute you. What's wrong with that?
Question at the back?
It was a couple of questions and an observation. I think the Solicitor General is on record when he floated the idea of DPAs that perhaps a percentage might go back to the SFO, perhaps not in quite the same rate as the US does, which perhaps gives rise to questions of whether they're pursuing the right sorts of investigations, but a limited percentage. So it'd be interesting to see how that develops. I was also thinking that we've been talking a lot about the US system and comparisons there, but it might be closer to home that we could find tools that might provide more of a stick and a carrot. The OFT, for instance, has the power to fine 10% of worldwide turnover to a company, but equally the carrot is that it gets 100% immunity if it comes through the door, and that to me seems a very powerful stick and a very powerful carrot. And yes, I've forgotten what my last question is about. Oh no, I do remember. I was just wondering, there hasn't been any mention yet, I don't think, about questions about double jeopardy and also jurisdiction shopping. And I was just interested in whether the panel thought that the introduction of DPAs might lessen jurisdiction shopping.
Any observations on any of these?
The first observation is that there is already a framework in place for prosecutors, both nationally and internationally, to work together to ensure that we get outcomes in the public interest. It's the prosecutors' convention for those cases that could be dealt with by way of various different arms of the state, and the protocol on concurrent jurisdiction cases with the United States. But the reality is that those conversations must take place at the earliest possible opportunity, and those engagements can lead to outcomes that are consistent with disposals in one or more jurisdiction and that don't trespass the whichever principle. And the reality is we've got the tools to do that, and we have to make those work. Peter?
Well, I think that the question of forum will be resolved by companies and their advisors choosing the most favourable jurisdiction in which to make their first report. In the competition sphere, it's interesting because you may remember a case called Norris. Norris was an interesting defendant because he's the only one who will ever have had his case decided in the House of Lords and the Supreme Court in the same set of proceedings related to his extradition for a competition-related offence in the US. But the interesting thing about his company was that it did go in and seek leniency. It was prosecuted in the US, and it for cartel conduct, and it then it separately went into the European Commission and got first in leniency 100% for the same conduct, which is a rather odd situation because normally you'd expect to have a global approach to the confession or the seeking of leniency, and you'd go in simultaneously to the relevant national competition authorities or the European Commission and seek leniency across the board. What's going to happen in relation to DPAs? I think something similar might apply, depending on how attractive the UK DPA carrot really is. If it's less attractive than going into the States, then people are going to the States first, do the main bit of the deal, and then ring up the SFO and say, well, actually, we've already been talking to the DOJ, we're nearly there. How about tagging along?
I think on I agree with everything that Peter says, we're regurgitated, but so far as sort of leniency and looking at that, it doesn't really work in the same way with bribery act because it's all about active bribery. So if you've got two companies committing bribery, one giving it, the other receiving, technically, it's only the giving that will want to get in early to avoid the Section 7 offence. But if it didn't exist, then that is something that would be highly appealing because it's something I'm asked all the time, which is if we go in, are we guaranteed leniency? What's our guarantee? You have to say nothing. Nothing. You might be lucky, and that does ward some off. Some will take a very robust view and say, you know what, thank you very much, we're taking your advice, we know what the risks are, we're aware our accountants might have dogged us in, there may be an investigation, but you know what, actually, we think we'll just stay quiet and see what happens. Add in the sort of provisions that you get in competition.
What would you mean, let the prosecution prove its case?
Well, it would be, yeah, well, it's slightly different if they surface, because generally speaking, they're quite rare. And of course, in cases where it's going to be obvious that law enforcement are going to get their hands on it, you're going to be knocking on the door anyway. But I like the concept of a form of guaranteed leniency because I think that would really support actually what the SFO want to achieve ultimately. Because if we think about what corporates are trying to do is clean up their act and deal with individuals who are criminal, it would get those corporates through the door quite quickly, and it would lead to some successful prosecutions probably more easily and cheaply for bodies like the SFO and the CPS regime.
I agree with that. I agree with everyone. The only thing I'd add, I suppose, is on the DPA point, and it's not quite a double jeopardy point, but it's related. One of the key issues for a lot of my clients is the extent to which admissions they make in the DPA agreement will be admitted in other proceedings, whether those are criminal or actually, just as importantly, whether it's a US class action type lawsuits. And therefore, and clearly the DPA proposal as proposed is that one will make formal admissions. It won't be a no admit, don't deny type settlement, which is sometimes used in NPAs in the States. And that, I think, will be, again, a significant factor in companies deciding whether this is something that they feel able to do.
Just coming quickly, the interesting thing about the libel settlement, I think, the Department of Justice settlement, as opposed to the CFTC settlement, is the libel DOJ settlement in relation to Barclays, something published, does not specify the offences. It doesn't. Some will disagree with me, but I don't think it does. The CFTC one does. So it's an interesting contrast in the same action, same investigation, but two different settlements, which actually, in a sense, are one of these is deficient, because it doesn't really say what the non-prosecution agreement in relation to Barclays related to, as opposed to a sort of generalised suggestion of fraud.
I wanted to say something about one of the issues that was on the original programme, which related to juries, which we haven't mentioned at all. And I think all I'm going to say is this, that in my experience it is always possible to prove a fraud. I think what we learned tonight was that the biggest laugh came a moment ago with the idea that the prosecution might be able to prove its case. If that's the situation that we're in, then another tool for the criminal justice system in the form of a DPA with sufficient carrot and stick may turn out to be a useful tool. However, I think my view is that as we go forward from here, taking into account what everybody's said, the mention of individuals over here I thought was the most interesting, that the picture that I've found from this debate is you will have a two-tier system where the corporates are wangling their way out through the DPA and the individuals are trying to get disclosure of all the documentation to prove their innocence. Prove their innocence in the Crown Court rather than the prosecution prove its case.
I've got nothing to add.
I was just one thing to add on that. The reality is a corporate can't be sent to prison. So if they achieve by DPA, a corporate cleaning up its act and actually beginning to act ethically, then that must be a positive thing. If they support law enforcement in dealing with criminals, then it brings more criminals into the criminal justice system and fraudsters and creates a result.
Long time ago.
Yeah.
I think it's quite clear that the night that I was going to give Peter is now going to go to me. Everyone's had a good old say, but what none of you have done so far is respond to the consultation document. So
Before the 9th of August.
There's time for one final question, if anybody has a question. I'm told there's lots of booze available for all of you outside. If there isn't,
And check, there's bottles of glasses, that's all ready. So.
if there isn't any further question, a reminder that this has been taped for posterity's sake. It's available on YouTube, so you can review the evening's proceedings. I'd like to thank Eversheds for hosting us all and continuing to host us until later on this evening. The panellists for providing us with their own insight based upon their own experience of dealing with fraud and corruption. I'd like to thank Satnam particularly. The SFO is on the receiving end of a great deal of comment, often criticism. I'll take my chairman's hat off now and explain my own insight. Coming at the matter from the commercial part, it's 26 years as Treasury Counsel, having done a great deal of work with colleagues at the SFO. I can testify to the dedication and commitment of individuals in the SFO. It may be that it's heartening to hear that the Prime Minister has indicated that the SFO will have no shortage of resources. There are some who've been able to work with the SFO and understood that in fact that's one of the major problems that the SFO has had, particularly when you consider that these cases involve millions of documents and you have very able lawyers like Peter and Ben and others who are able to call upon considerable body of personnel, expertise and resources. Quite rightly, of course, because that's the situation that we operate within. So there seems to be consensus that the Bribery Act is an important development. There seems to be some degree of consensus that resources are an issue that need to be addressed. The Solicitor General has very kindly stayed here and given us an indication of the government's commitment to ensure that the SFO is here to stay, and it will be fighting top-end fraud, bribery and corruption. If you have any further comments or questions for any of the panellists, or perhaps even the Solicitor General if you'll stay with us, please do feel free to ask outside. For now, thank you all very much for coming and joining us, and we look forward to seeing you outside.